They started this, not me. If it were up to me, there'd be a 60-vote requirement in the Senate today. Denying Judge Gorsuch the votes necessary to go to the floor was just the beginning of the end of a process that had served the country well. How could anybody in their right mind believe that Judge Gorsuch wasn't as qualified as Sotomayor and Kagan? How could anybody in their right mind, after listening to Judge Barrett, not understand she's not just qualified, she's incredibly qualified? So qualifications apparently don't matter anymore. It's about trying to create a situation for your favor politically. I don't know where this ends or how it ends, but I do know this. After listening to the excerpt of Vice President Biden's explanation about court packing, I am more confused than ever. The one thing I can say is that the real energy in the Democratic Party is to pack the court, is to expand it from 9 to whatever number they need to make it liberal. And as to my good friend, Senator Feinstein, what happened to her by showing an act of human kindness tells you all you need to know about what awaits a senator who gets in the way of the agenda they have for our nation, beginning with the court. The day we start changing the number after every election to make it the way we would like politically, partisan-wise, is the end of the independence of the court. Lots at stake in this election, but today I want to celebrate. I want to celebrate the fact that Judge Amy Barrett will be reported out of this committee unanimously, that to all the young women out there like Amy Barrett, this is a big day for you. To the country as a whole, you're going to have an associate justice on the court that you should be proud of. This is a good day. If you don't believe me, just listen to what the ABA said. The American Bar Association is not high on Senator Lee's list, and many of you. I think they do give some Republican nominees a hard time, but I've continued to use them because I keep as many traditions in place as I can. But to folks who are watching this hearing, their job is to evaluate the nominee in 3 categories: professional competency, character, judicial disposition. They spent hundreds of hours, talked to hundreds of people from all walks of life about this Judge Barrett. And here's what they found. The American Bar Association Standing Committee on the Federal Judiciary has completed the evaluation of the professional qualifications of Judge Amy Barrett. As you know, the Standing Committee confines its evaluation to the qualities of integrity, professional competence, and judicial temperament. A substantial majority of the Standing Committee determined that Judge Barrett is well qualified, and a minority is of the opinion that she is qualified to serve on the Supreme Court of the United States. The majority rating represents the Standing Committee's official rating, which is the highest you can get. I asked the 2 presenters a question. Would both of you feel comfortable going before Judge Barrett? They replied, absolutely. Another piece of information was from Ms. O'Hara. She was the dean of Notre Dame Law School while Judge Barrett was a professor. Remember what she had to say. I have only communicated with this august committee on 2 occasions. The first was 10 years ago when I wrote a strong letter in support of now Justice Elena Kagan, whose term as Dean of Harvard Law School overlapped with my own. The second is today introducing and endorsing Amy Coney Barrett, in equally strong terms. Some might find these recommendations in juxtaposition, but I find them entirely consistent. So do I. I voted for both. The committee will hold over S 4632, Online Consent Policy Modernization Act. I ask unanimous consent that notwithstanding the motion of October 15th, setting the vote on the Barrett nomination at 1 p.m., the committee proceed immediately to vote on the Barrett nomination. Any objection? Without objection. On the motion to report the nomination of Amy Coney Barrett to be an Associate Justice of the Supreme Court of the United States, the clerk will call the roll.
Favorably to the floor.
Favorably to the floor, the clerk will call the roll.
Mr. Grassley.
Aye.
Mr. Cornyn. Mr. Lee. Mr. Cruz. Mr. Sass. Mr. Hawley. Mr. Tillis. Ms. Ernst. Mr. Crapo. Mr. Kennedy. Mrs. Blackburn. Mrs. Feinstein. Mr. Leahy. Mr. Durbin. Mr. Whitehouse. Ms. Klobuchar. Mr. Coons. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Ms. Harris. Mr. Chairman.
Aye.
Mr. Chairman, the votes are 12 yeas, 10 no votes.
The nomination will be reported favorably to the floor with a unanimous vote. Senator Cornyn.
Mr. Chairman, I'll just take a couple of minutes. I just find this to be a surreal environment we're in, where our Democratic colleagues announced yesterday they're going to boycott one of the most important votes this committee will have, probably during our entire senatorial tenure, and that is a vote to confirm, provide advice and consent to a nominee for the Supreme Court of the United States. But I just want to comment on the pictures that are in their chairs, like this is some sort of sporting event during COVID-19, and rather than show up and do their job, they choose to continue the theater that was part of the hearing. And of course, this is all pretextual. Their argument, as I understand it, is somehow Amy Coney Barrett will violate her oath of office, contrary to everything she has done and who she is, and somehow that the Affordable Care Act is in jeopardy. She explained, I think with great skill, the issue before the Supreme Court. It's really one of severability, which is a very technical doctrine. It doesn't have anything to do with the merits of the Affordable Care Act. It has to do whether you can sever the unconstitutional portion from the rest of the ACA and that it will survive. But the fact is, Democrats have already moved on from the ACA. In Senator Cruz in my state, in the last 6 years, the premiums for an individual under the ACA have gone up, I believe, 57%. The average deductible is about $3,000. For a family of four, the deductible is $12,000, which means that in essence, you do not have insurance coverage. You're essentially self-insured. So what Democrats have done is they realized that all of the promises that were made to the American people leading up to the passage of the ACA, they have been broken. I remember President Obama saying, if you liked your policy, you could keep your policy. If you liked your doctor, you can keep your doctor. None of that's true. They said that we would have essentially universal health insurance coverage. That's obviously not true. So ACA has failed. Our Democratic colleagues recognize that. And that's why they have, from the presidential candidates running in the primary, all the way down to people running in this election on November 3rd, including in my state, have advocated a single payer system, sometimes called Medicare for all, sometimes called the public option, but it's all a slippery slope toward a single payer system. And I just think it's important to point out what they are advocating, because it is extraordinarily radical. For the 100 and maybe 80 million Americans who get their health insurance on the job, they would eliminate that. They would take that away from them in order to put them on a single-payer government program. Medicare, as we know, has its own financial problems and something we obviously need to shore up. It's a commitment we've made to our seniors that if you pay into the Medicare program, you're going to have health coverage when you become eligible. But dumping 330 million people into the Medicare program in a single-payer system will bankrupt it. And we know that providers depend on a payment mix between Medicaid, Medicare, and private insurance in order to pay the bills. Without the private insurance premium or payments, our healthcare providers, our hospitals, including those in rural parts of our states, would be bankrupt. So I just think it's really important to just lay out the facts here. This is all for show. They have given up on the ACA because they realized that it did not fulfill the promises that were made when it passed. Now it's unaffordable to most ordinary Texans and Americans. And so they have thrown that out the window in favor of a single-payer system. And finally, you know, Senator Schumer said everything is on the table if they win the majority. I think you've observed, Mr. Chairman, that if the shoe were on the other foot, we have no doubt what they would do under these circumstances. But beyond that, Senator Schumer has said that the legislative filibuster is in jeopardy, that they will turn this into simply a partisan body where you don't need to do the hard work to get bipartisan support. They would consider turning D.C. into a state, and the state would get 2 senators. Puerto Rico, a state, and get 2 senators. They want to permanently transform this country. This isn't about incremental change. This is about revolutionary changes in our country. And then finally, as we've all observed, they're advocating packing the Supreme Court with additional partisan judges. And as Ruth Bader Ginsburg pointed out, there goes the crown jewels of the American Republic, which is our independent judiciary. It becomes nothing but another political body, a second legislative or political branch. So I just wanted to take a minute and thank you for your patience to lay out my thoughts and observations with regard to these theatrics with which our Democratic colleagues are presenting us today. This is all for show. This is to try to capture a narrative which is simply false and to cover up what they are really about. So thank you, Mr. Chairman.
Thank you, Senator Cornyn, and I agree with what you said. Why don't we do the business of the committee? We got a few more judges and the subpoena requests. Let's get through that, and I'll stay around, and anybody who wants to speak, we'll do so. On the motion to report the nomination of Benjamin J. Beaton to be United States District Judge for the Western District of Kentucky, favorably to the floor, the clerk will call the roll.
Mr. Grassley.
Aye.
Mr. Cornyn.
Aye.
Mr. Lee.
Aye.
Mr. Cruz.
Aye.
Mr. Sass.
Aye.
Mr. Hawley.
Aye.
Mr. Tillis.
Aye.
Ms. Ernst. Mr. Crapo. Mr. Kennedy. Mrs. Blackburn. Mrs. Feinstein. Mr. Leahy. Mr. Durbin. Mr. Whitehouse. Ms. Klobuchar. Mr. Coons. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Ms. Harris. Mr. Chairman.
Aye.
Mr. Chairman, the votes are 12 yeas and 10 not present.
The nomination will be reported favorably to the floor. On the motion to report the nomination of Christy Johnson to be United States District Judge for the Southern District of Mississippi, favorably to the floor, the clerk will call the roll.
Mr. Grassley.
Aye.
Mr. Cornyn.
Aye.
Mr. Lee.
Aye.
Mr. Cruz. Mr. Sass. Mr. Hawley. Mr. Tillis. Ms. Ernst. Mr. Crapo. Mr. Kennedy. Mrs. Blackburn. Mrs. Feinstein. Mr. Leahy. Mr. Durbin. Mr. Whitehouse. Ms. Klobuchar. Mr. Coons. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Ms. Harris. Mr. Chairman.
Aye.
Mr. Chairman, the votes are 12 yeas and 10 not present.
The nomination will be sent to the floor favorably. Motion for Taylor B. McNeil to be United States District Judge for Southern District of Mississippi. Favorably to the floor, the clerk will call the roll.
Mr. Grassley.
Aye.
Mr. Cornyn.
Aye.
Mr. Lee.
Aye.
Mr. Cruz. Mr. Sass. Mr. Hawley. Mr. Tillis. Ms. Ernst. Mr. Crapo. Mr. Kennedy. Mrs. Blackburn. Mrs. Feinstein. Mr. Leahy. Mr. Durbin. Mr. Whitehouse. Ms. Klobuchar. Mr. Coons. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Ms. Harris. Mr. Chairman.
Aye.
Mr. Chairman, the votes are 12 yeas and 10 not present.
Thanks for watching, and if you haven't already, please consider subscribing to our channel. And while you're at it, please leave us a comment. Thank you for watching.